Welcome to a discussion on America's fastest growing industry. Hi, I'm James Waggoner, and today we're going to take a look at bankruptcy. This is an unfortunate truth, but the number of personal bankruptcy filings has more than tripled in the last decade. What used to be a rare occurrence, less than one case per 1,000 in the population, is no longer the case. Particularly in the current economic recession, bankruptcy courts are backlogged with new filings. Aside from the financial issues is the emotional stress that inevitably goes along with bankruptcy. In fact, bankruptcy has become an industry unto itself. And here we're referring to the growing number of lawyers, debt counselors, mental health professionals, as well as bankruptcy court personnel. We must not forget to include foreclosure specialists, auctioneers, the list goes on. In a period when the general level of unemployment nationwide is over 10%, there is a shortage of trained, experienced workers in the bankruptcy field. Many people are attracted to the pre-bankruptcy areas, such as mortgage modification specialists and debt reduction people, and these schemes are of questionable value. If you're under severe financial stress, be very careful in seeking out these service providers. More about that in just a few minutes. We have discussed the level of consumer and government debt in previous episodes that represents long-standing culprits. However, a rising number of bankruptcies are being caused by two other forces. Number one, the mortgage crisis, and number two, the uninsured number of people needing health care. Historically, there was a severe stigma attached to declaring personal bankruptcy, but much has changed because of the over-leveraging in all sectors, government, corporations, as well as individuals. Who can place greater blame on the individual when most of the major airlines in this country have been reorganized under bankruptcy laws, and General Motors, once the most respected corporation in the world, became a victim of bankruptcy in 2009. But how will you know if bankruptcy is right for you? The simplest answer is that if all of your debts exceed the value of your assets, you're technically insolvent. But does this mean that you're a good candidate for bankruptcy? For example, your assets consist largely of bonds or common stocks. The value of these assets can be quite volatile, especially under depressed market conditions that we saw in 2008 and early 2009. In the case where the value of your home is more than 20% below your mortgage and you have other debts that are more than 2 times your annual income, you may want to consider your options. But before taking any action, bankruptcy has serious and lasting consequences. Even though the traditional stigma has faded, the impact on your credit record and potential employment prospects should never be overlooked. If you are seriously contemplating bankruptcy, here are just a few do's and don'ts. Number 1, consult at least 3 reliable attorneys specializing in bankruptcy. Usually the first visit is free. Number 2, consult at least 3 debt reduction negotiating firms. If you have a large credit card debt, banks are showing willingness to reduce principal and interest payments. Use only those firms that work on a success basis. Do not pay any money until satisfactory services have been rendered. Number 3, do not waste your money on mortgage modification schemes. Attorney-based companies are governed by strict state laws, but there are many scam artists insisting on upfront fees. In many states, upfront fees are illegal, so the scam artists merely locate their business headquarters in an unregulated state. Even when successful, the process is long and can be highly frustrating. Most of the time, unfortunately, banks have been unwilling to modify mortgages to any material degree, so don't waste your time and money. And number 4, do not waste your time on credit counseling or credit repair. If your debts are all that high and you're more than 60 days late in your payments, it's too late for credit counseling. The damage has already been done. As for credit repair, there'll be plenty of time for that later. One final point that's very important. Bankruptcy is governed by state law, and therefore there is little advice about the subject that can be applied universally. This is why it's so important to seek legal counsel from the very start. What we're going to provide you with today are a few simple things to help you get started and familiar with a rather complex issue. Now, no matter what state you reside in, there are 6 types of bankruptcy under the Bankruptcy Code, located in Title 11 of the United States Code. An important feature applicable to all types of bankruptcy filings is the automatic stay. The automatic stay means that the mere request for bankruptcy protection automatically stops and brings to a grinding halt most lawsuits, repossessions, foreclosures, evictions, garnishments, attachments, utility shutoffs, and debt collection harassment. And that last part cannot be minimized for its importance. For practical purposes, we're going to focus only on 3 of the most common individual filings, and those 3 are Chapter 7, 11, and 13. More detail can be found online under the Federal Bankruptcy Code, and many bankruptcy attorneys are available that offer free initial consultation. First, we're going to talk about Chapter 7. This is the basic liquidation for individuals and businesses, also known as a straight bankruptcy. It's the simplest and quickest form of bankruptcy available. Next, Chapter 11. Chapter 11 is the rehabilitation or reorganization used primarily by business debtors, but sometimes by individuals with substantial debts and assets, known as corporate bankruptcy. It is a form of corporate financial reorganization which typically allows companies to continue to function while they follow debt repayment plans. Finally, Chapter 13. Chapter 13 is the rehabilitation with a payment plan for individuals with a regular source of income. It enables individuals with a regular source of income to develop a plan to repay all or part of their debts, also known as wage earner bankruptcy. What are the major differences? We will give you the principal differences, but keep in mind that there may be differences on a state-by-state basis. Okay, first of all, in a Chapter 7, a debtor surrenders his or her non-exempt property to a bankruptcy trustee, who then liquidates the property and distributes the proceeds to the debtor's unsecured creditors. In exchange, the debtor is entitled to a discharge of some debt. Many individuals in financial distress own only exempt property, things such as clothing, household goods, maybe an older car, and will not have to surrender any property to the trustee, which is kind of comforting under a period of great financial stress. The amount of property that a debtor may exempt varies from state to state. Chapter 7 relief is available only once in an 8-year period, and generally the rights of secured creditors to their collateral continues even though their debt is discharged. There are important qualifications for Chapter 7 filings. The 2005 amendments to the Bankruptcy Code introduced the means test for eligibility for Chapter 7. An individual who fails the means test will have his or her Chapter 7 case dismissed, or may have to convert his or her case to a Chapter 13. Now, in Chapter 11, the debtor retains ownership and control of its assets and is, quote, retermed a debtor in possession, also known as DIP, for those of you who are legal analysts. The debtor in possession runs the day-to-day operations of the business, while the creditor and the debtor work with the bankruptcy court in order to negotiate a complete plan of reorganization. Upon meeting certain requirements, for example, fairness among creditors, priority of certain creditors, things like that, creditors are permitted to vote on the proposed plan. Now, if the plan is confirmed, the debtor will continue to operate and pay its debts under the terms of the confirmed plan. If a specified majority of creditors do not vote to confirm a plan, additional requirements may be imposed by the court in order to confirm the plan. Relief under Chapter 13 is available only to individuals with regular income whose debts do not exceed prescribed limits, and those prescribed limits will probably vary state by state. If you're an individual or a sole proprietor, you're allowed to file Chapter 13 bankruptcy to repay all or part of your debts. Under this chapter, you can propose a repayment plan in which you pay your creditors over a 3 to 5 year period, for example. If your monthly income is less than the state's median income, your plan will be for 3 to 5 years unless the court finds just cause to extend the plan for a longer period. If your monthly income is greater than the state's median income, the plan must generally be for 5 years. Now, a plan cannot exceed the 5-year limitation. Now, Chapter 7 and Chapter 13 are efficient bankruptcy chapters often used by most individuals. The chapters which almost always apply to consumer debtors are Chapter 7, known as straight bankruptcy, and Chapter 13, which involves an affordable plan of repayment. Wow, I hope you've gotten all of this, and hopefully none of you will really need to use it, but if you do, it can come in very handy. And that's all for this edition covering bankruptcy. Please refer to any of these 10 episodes on finance that are available on this website, or contact me directly, James Waggoner, PCM Advisors, 310-383-0257, or visit our website at pcmadvisors.us. Thanks for joining us. Hope to see you again.